SJC-11957, Commonwealth v. Daisy Obie.
Good morning, Ms. Peterson. Give us one moment, and we'll get you started.
Back to this.
Thank you. All right, you may proceed.
Good morning. May it please the court, my name is Attorney Kim Peterson, and I represent the appellant in this matter, Dr. Daisy Obie. My father always told me two things never to argue, politics and religion, and yet here we are today. And we're here first and foremost because the probationary conditions that Judge Yee imposed upon Dr. Obie clearly violated her free expression to practice her religion.
All of them?
Pardon me, Your Honor?
All of the conditions?
The very first one, Your Honor, that she must learn about the Muslim faith. That very first foremost.
Wasn't it just that she needs to take a course?
No, Your Honor, if you read the entire transcript where the judge states to Dr. Obie, I want you to learn about the Muslim faith. Again, I want you to learn about the Muslim faith. Then he goes on to, I want you to take...
What's the written condition?
The written condition, Your Honor, is that she must attend, and probation must know about it, and that she must respect the people of the Muslim faith.
Okay, but just with respect to the course, it's that she must attend a course, correct?
That's correct, Your Honor.
Okay.
But
So
it's
she
not
could
just...
attend the course and basically listen to her iPad.
Again, Your Honor, that's open-ended. It doesn't say whether she has to successfully complete the course, but it does say that she's going to take it either at the Harvard School of Divinity or at the Islamic Center Society of Boston and Cambridge.
So if we were simply to interpret that to say you must attend a certain number of classes, or however it was framed.
I think that's still problematic, Your Honor. I mean, this is clearly a violation of her Article 2 under the Massachusetts Declaration of Rights.
And why is it a violation of one's right to freedom of religion to learn about another person's religion?
Because, Your Honor, it improperly imposes that other religion that she has to learn about. Dr. Obie it's not disputed, is a Christian.
Is it a tenet of the Christian faith that one should not learn about other religions? Is that the tenet of any religion, that one should not learn about other religions?
I don't think that this court judge has ever taken the position that's the tenet that they're examining. It's whether we're imposing or coercing another religion on that person.
But are they being required to practice the Muslim faith or Islam?
Again, Your Honor, that's not the issue. The issue is that it's being imposed under Article 2.
Okay, so if they imposed a course in mathematics, is that a violation of?
Mathematics is another whole different, separate issue, Your Honor. This is religion.
But is it the imposition that you're concerned about, or is it, it's a religious subject, not a religious practice that they're being required to
But it doesn't matter, Your
learn
Honor.
about?
I don't believe that matters, Your
Why
Honor.
not?
Because as the judge dictates, it is singularly the Muslim faith that he wants her to learn
Well,
about.
suppose, it's a probationary condition because you've been driving recklessly, that you need to take a course in, I don't know, seeing the results of crashes.
That's
And
correct,
you're-
Your Honor.
And you're being required to learn something you didn't particularly want to know, but there you are, you're being required to do it. That's okay?
That's okay, Your Honor, because
It has nothing to do with religion.
because it's secular. That's correct, Your Honor. A brains at risk course that a drunk driver has to take has been mandated by the statute
Right.
in order to deter and rehabilitate that offender.
But all the judge was requiring was that the person educate themselves about a particular religion. He wasn't requiring them to practice that religion.
And actually, that's untrue, Your Honor. He was asking her to learn to respect Muslims.
That's a
and to learn the
different
faith.
condition, though, right?
It's still under that condition, Your Honor. It is not just piecemeal that he bulleted these points, take a course in Islam. It is part and parcel of his desire that she learn about the people of the Muslim faith.
What if the judge had ordered her to, is it the Muslim faith that she has a problem with? Would she have the same issue if it were Buddhism or Hindu?
I don't know if that's even an issue in this case, Your Honor.
No,
And
I
even if it is-
understand.
Even if it is, that would still be the state singling out one religion for her to have to learn about and to respect.
I'm just trying to figure out if her problem is having to learn about any other religion, or is her problem having to learn about Islam?
I think any time the state imposes one singular religion or any religion on a person, Your Honor, I think there is a problem.
Well, what if the judge said, okay, I want you to take a course in Judaism, a course in Islam, a course in Buddhism, and a course in Hinduism? Would that have saved the day for the order?
Possibly. I mean, if the judge said, I want you to take it on world culture or world religions,
Yeah,
that's
what about
one thing.
world religions?
Again, but his directive was that I want you to learn about the Muslim faith.
But that was because it was reasonably tailored to the problem that she got herself into.
But it's too tailored, and it's too tailored that, quite frankly, it infringes on her expectation of, her free expression of religion under our Article 2, under the Establishment Clause, and under Article 46, Section 1.
Yeah, I don't get that. Establishment clause? That
you know,
the court is establishing Islam as an official religion because she's being ordered to attend a class about Islam? Is that your argument?
Your Honor, under the Lee versus Wiseman case, there's a great quote in there, Your Honor, that states, the Establishment Clause was based on the principle of the Founding Fathers, that they knew that once government, even in an effort to be tolerant of a religion, it becomes coercion and indoctrination. And that's the problem.
Okay, but I still don't understand what the establishment is. You're saying that the judge had established some official religion? I'm just trying to figure out how it fits into either free exercise of her religion or the establishment of an official religion.
Well, the religion is the Muslim faith. It is replete throughout his instruction, throughout his probationary terms, that she learn about the Muslim faith.
Can I just
Yes, Your Honor.
are you suggesting, I'm not, just tell me if I'm wrong, that she should be entitled, anybody should be entitled to hold to their own religious beliefs, whatever they are, and to be intolerant of others? And as long we're free to be intolerant of others and have our own, and we shouldn't be ordered to be less, unless there's behavior, and then you look at the behavior. And by ordering someone, to be more open-minded about the world religions and what they can offer to other humans in the world, and that it shouldn't, that's what's wrong with it. That by saying be more tolerant of a religion you've expressly not been tolerant of, that is a violation of her closely held beliefs as a Christian minister. She just doesn't want to be tolerant of other religions. She believes in this one. Is it something like that?
It is, Your Honor, and that would be the
So
Article 2
would you
analysis.
say that what's required here is something that's focused on the behavior, on the harassing behavior, on the pushing someone down the stairs behavior? Perhaps there are certainly others, right? There's in the record, there's evidence that this behavior, not quite this extreme, but intolerance of other tenets. Maybe it's just that she's has a personality issue and doesn't express disagreement appropriately. That could be addressed, right?
That's correct, Your Honor. And then that's what I think is addressed in Article 2 of the Massachusetts Declaration of Rights, is that the court is restraining her liberty, if you will, as to this religious practice.
Well, she
Should be
just-
intolerant. I'm not trying to be.
No, that is correct, Your Honor.
Okay.
Are you suggesting that part of the Christian faith is the right to be intolerant of other faiths? Is that her position?
I'm not stating that is her position, but I am stating that to practice one's religion over another or hold true to those tenets that other religions should not be taken into account
Well,
is the tenet
I'm
of
just
some
trying to
religions.
understand if she's saying that part of Christianity is that I don't have to respect or know about other faiths, because that's at the bottom of why she disagrees with this. And I didn't understand that to be part of the Christian faith, that you don't have to be tolerant of other faiths. It's not the same as some other part of the faith that everybody understands.
That's
But
correct, Your Honor, but-
is she making this up, that this is her version of Christianity?
No, Your Honor, and I'm not going to speak to that, but what I am going to speak to is that in the holding of the Dissolette case, in that case, Roman Catholics did not want to rent to people that were unmarried.
Right.
And the court
Well,
held...
that's a more mainstream part of the faith. You know, there's something in the Bible about cohabiting, but I don't know that there's anything in the Bible about being intolerant of other faiths.
But Your Honor, just because it's not in the Bible, it doesn't mean that that's not what your beliefs are and that's what your faiths are. And as we know, the Bible can be interpreted in so many
No,
different
I
ways.
understand. I understand. Just what I'm trying to get at is whether or not a person would have the right to insist on something that is not an understandable or accepted part of the faith is the issue I'm trying to raise.
And that's correct, Your Honor. If you hold one faith so dear, it shouldn't be up to the state to then make you learn another religion or respect people of those other religions.
But the judge, there's an inherent requirement of respect because she was prosecuted for assault and battery. She didn't raise a First Amendment defense to the criminal charge, did she?
No, she did not, Your Honor.
On that score, I thought part of your argument was that these conditions, is it? That these conditions have nothing to do with the actual conviction? Is that part of your argument?
The argument raised below was that this was not a hate crime and therefore there shouldn't be an element that she has to learn about the Muslim. No, I don't think that argument needs to be made, quite frankly, Your Honor. I think she has the protections of the state constitution, that she doesn't need that. I think she has the protections under, like, as I stated before, Article 46, Section 1 as well. As this court just found at the Magazu case, I mean, following that procedure, I think that this defendant falls under that as well. The government cannot show that there is some unusual government interest that needs to be protected. While it is some protection that, you know, people have a right to be respected and their rights not to be pushed down a flight of stairs, but there's no right that the Muslims themselves have to be protected.
So
in
if
the
it was a
whole
hate
body.
crime, and if it had been, let's say the other two tenants earlier also had been Muslims, there's no indication in this record that they were. This is of the tenants that had problems with the individual, the defendant here. There was only this tenant that was known to be, on the evidence, to be a Muslim. What if they'd all been Muslims and the crime had been a hate crime? Would it be okay then?
I think it would be the stronger argument for the government, but I still think that would be encroachment by the government to insist upon probationary terms that singles out one religion on another person's religion.
If I can separate, you appear to be conflating the attending the course with respecting the rights, respecting people of the Muslim faith. And let me see if we can separate that, because I understood that it was those to be separate conditions. If we were to interpret the judge's probationary conditions to require, one, that she attend a course on Islam, period, and two, that she not commit any violation of civil rights, would you consider that to be an unconstitutional set of conditions?
Well, as to the latter, I think you don't, I think there are laws in order to prosecute the defendant if she violates someone's civil rights in the future.
Okay, so to the extent that to say respect the rights of people, if we interpret that to mean you may not commit a violation of civil rights, you're fine with that?
If we're talking about the word respect, I think that word respect, and I think the Commonwealth would probably agree, seems to be an overreaching of the respect federal laws, respect state laws, and that.
Okay, so but if we were to interpret respect to mean comply with civil rights laws, you're fine with that?
I am fine with that, Your
Okay,
Honor.
and I understand the difficulty of trying to determine whether there's a violation of respect. So let's then turn to the second. If it were to be simply that one attend a course, not necessarily that one be tolerant of that religion or show respect for the religion, but simply that one attend a course, would you have problems with that?
I would have a problem with that, Your Honor, Article 46, Section 1. I would have a problem with that because under the four-part test, it is no doubt that the defendant holds a sincerely held belief and that this would be a conflict with her belief.
What's the sincerely held belief?
I'm sorry, Your Honor?
What is the sincerely held belief?
That she is Christian and Christianity is her faith and that she should not have to learn about another religion nor another faith.
But what's the conflict with that?
In
I
many-
don't understand where there is a conflict with that sincerely held belief. That's where I'm having some problems.
Because some Christians believe, Your Honor, that that is their faith, that an encroachment upon that by anyone.
But I don't understand what you're talking about.
I mean, you can be an deeply religious Catholic and be a professor of religion and know a whole lot about a whole lot of world religions, and is that violative of the tenets of Catholic religion?
If it's forced upon you, absolutely, Your Honor. And it's bad public policy. This is against any kind of public policy that this court has ever, or our constitutions have ever allowed. In other words, if the roles were reversed and the defendant was a Muslim who pushed a Christian down the stairs, would we then require a Muslim to take Christian classes?
Yes.
So if somebody wants to major in religion in college and they happen to be a Catholic, and one of the requirements is that you take a course in Judaism and take a course in Buddhism and take a course in Islam, and the student says, that's a violation of my religious beliefs, and I want to major in religion. You're violating my civil rights. Is that what you're saying?
No, that's not what you're saying. In fact, Your Honor, I majored in religion when I was at Merrimack College, and that's not what I'm saying. But what I'm saying...
If
This is the
judge-
government. This
This-
is the government ordering someone to learn about a specific religion.
Thank you.
If the judge had said in this case, you have attacked somebody because of their religion, and I am going to sentence you with that factor in mind, would that have been an illegal sentence?
I'm sorry, Your Honor.
If the judge had said at the time of sentencing, you have committed an assault and battery on a person because of their religious faith, and I am going to take that into consideration in imposing sentence on you, would that have been an illegal sentence?
No, Your Honor, I don't believe that's an illegal sentence. I think the probationary terms are illegal here.
Right, but that's part of the sentence. But if this were a hate crime, I think if this were a hate crime and she were convicted of attacking the tenant because she was a person of Muslim faith, would you consider this to be an illegal probationary condition?
Yes, Your Honor. I would.
And taking Justice Spina's example, if this were not Merrimack College but UMass, a public school, which imposed that requirement for those who choose to major in religion, would you consider that to be a state-imposed obligation that's in violation of the Free Exercise Clause?
No, you're wrong. I would not. This is a probationary terms, and what is going to happen to Dr. Obi if she does not go to an Islamic class and learn about the Muslim faith is that she's going to be in violation of her probation.
And perhaps go to jail.
Correct, Your Honor?
She has to go. I don't know that it says she has to learn about it, does it?
She has to provide probation with the proof that she goes. But that's another question. What if she fails? What if she fails this course? What if she
Doesn't
takes
say
it?
she has to pass it, just says she has to go.
So then there's ambiguity in the probationary terms, Your Honor, whether she's got to go and whether she's got to pass it.
Well, no, he says, I want you to enroll and attend an introductory course on Islam.
If we clarify the ambiguity, are you satisfied?
No, Your Honor. This will never be satisfied, nor should it ever be satisfied, Your Honor.
Okay, thank you.
Good morning, Your Honors. May it please the Court. I'm Mary O'Neill, an Assistant District Attorney in Middlesex County, and I served as the trial prosecutor in this case.
So let's say the judge says to someone who has been convicted, you know, what you did here also violated several of the 10 Commandments, and I think you would really benefit by taking a course about the 10 Commandments. It's just not very Christian of you, what you've done. Problem?
It would depend, Your Honor. The problem would be in what context is that course? Is it in an academic setting? Is there a requirement that she adopt those beliefs? What we have here is a requirement from Judge Yee that this defendant, who held herself out as an academic and scholar with multiple divinity degrees, be exposed to information, again, in an academic setting.
In order for her to change her mind, so
No,
she would respect other religions, learn about other religions?
To be exposed to information and offer her insight into her victim, the woman that she pushed down the stairs, who was a Muslim, and that push did appear at least partly motivated by her animus towards this woman's Muslim faith. That background of that relationship is part of the context of the order, and that is why it is reasonably related to probation goals.
So if people offend other people because of their religion, and that offense is somehow caught up in some criminal activity because words are exchanged, the court should be in the business of ordering people to learn about other religions?
Your Honor, in this
Our
limited,
business?
it's not in the business to force people to learn about other religions. It's in the business of the court to encourage people to not commit further violent crimes, to deter people from criminal
And do you
conduct.
think, taking this course will prevent her from committing further violent crimes?
That is part of the aim, Your Honor, to
How about
rehabilitate.
anger management?
That would have also been acceptable, but that, just because that was not what was ordered by this judge, does not make this academic course one of a range of reasonable alternatives that the judge could have ordered.
Isn't this a slippery slope? Isn't this just opening the door to all kinds of potential abuse?
I don't think it is, Your Honor. Even though the Commonwealth did not request this particular condition, it's clear from the record that the judge considered this particular defendant's background. He ordered an aid in sentencing evaluation so that he could take more information about her mental health history, whether that's something that played into this crime. And he also considered that she did hold herself out as an academic, so the order to participate in a class is entirely tailored, as this court has said should be.
But participating in a class, let's think about for a minute, what does it mean when you say to somebody, participate in a class? The reason you want them to participate in the class, as you have said before, to be exposed to ideas. But isn't really what he's after for her to change her mind?
Your Honor, I would submit that it's for her to change her conduct. This is a woman who, as the court noted in sentencing, she had been given the opportunity to simply follow the law with pretrial probation. She was not successful and then came back before the court. So inviting her to be exposed to more information about another culture is not...
But suppose it was a course about Muslim history or Muslim culture.
Those
Would
would
that
also-
have been different? Wouldn't that have been different than a course about the Muslim faith?
I don't think so, Your Honor,
What
because
does faith have to do with this? Isn't it really?
it's the topic of Islam. She's not required to adopt any religious beliefs.
I want you to learn about the Muslim faith.
Yes, and a history and culture within that faith. She's not required to adopt any beliefs from the Muslim faith. She's not required to support any beliefs or even acknowledge that those are valid beliefs. That's very much in contrast to cases where the court has said in situations of imposing Narcotics Anonymous or Alcoholics Anonymous, those are scenarios where in order to participate in that program, you're actually engaged in what has been recognized as a religious exercise. That's not the case here. She wasn't ordered to go to a mosque. She wasn't ordered, it's not like being ordered to go to catechism class or Hebrew school or any kind of religious activity. She was ordered to attend an academic class. And once again, this is something that is reasonably related and specifically tailored to this defendant who, once again, in her testimony and in the sentencing, repeated how she was an academic. And so the idea that she'd go to a class at an institution of higher education, or if she chooses at a cultural institution, is not offensive to her civil rights.
Was part of the evidence in this case, I'm confused about the other proceedings, but was part of the evidence in this case her statement to the victim's children, you wicked children because you're Muslims, or was that?
That was part of
That
the
was part of
evidence,
the
Your Honor.
evidence in this case.
It was. It was in the, I'm not sure of the page number, but it was as part of the victim's testimony.
And was it, go ahead.
No, I was going to ask a different question. You go ahead.
Was it apparent to the judge that this kind of language or these kinds of remarks was going to be part of the evidence in the case?
Your Honor, I don't know whether it was apparent to the judge. It was certainly apparent to the defendant because it was all information that had been provided in advance in discovery.
And when the jury was impaneled, did the judge ask questions about whether or not such language might affect the judgment of the jurors?
The judge did not, nor did the defendant request that the judge do so. This was a situation where the victim, as was described in the record, wore a head covering known as a hijab. It was the victim did, and then also the juror, if you're getting to that issue. The juror also wore a similar head covering. It was of a style slightly different, but also covered her hair. Her face was exposed, but it was clearly...
Is that described in the record, or is that your memory of it?
Both, Your Honor. It was described in the record as by the judge, and I mentioned it, that they wore similar head coverings consistent with a person who follows the Muslim faith. And the judge also acknowledged that when I raised it and when I challenged that the peremptory challenge was for a religious reason. And at that point, the judge made an inquiry and gave the defendant an opportunity to explain some non-religion-based reason, and he simply wasn't able to. Although he asserted, the defense attorney asserted that it was surely not based for any issue with race, creed, or
Out of curiosity,
otherwise.
if the evidence is going to include hate speech about a specific religion, wouldn't it be appropriate for the judge to at least inquire as to whether or not that might offend someone on the jury?
Your Honor, it would have been open to him to inquire of that. Similarly, it was open to the defendant to ask for that.
He didn't know that was going to be part of the evidence at the time, did he?
The judge did not. However, as I noted, the defense attorney did and the defendant did, but I would suggest that was part of their trial strategy in that they claimed that this woman was fabricating the entire incident and that she was then taking those claims and what she was going to say that the defendant said to her in order to cash in. I forget the terms that were exactly used, but in order to make some money off of an MCAD complaint, off of a civil suit. That was a strategic decision that they also wanted those statements in.
For purposes of a peremptory, there's a challenge in the brief to the questions not posed by the judge to discover whether or not juror number 2 was in fact Muslim. Does it matter whether juror number 2 was in fact Muslim, or for the purposes of the peremptory analysis, is it sufficient that somebody could reasonably think that she was Muslim?
It does not matter, Your Honor. It was enough that it would be, that there would be an impression that she was Muslim. And the reason for that is whether somebody is actually African American or actually some other protected group, if on its face it appears that the challenge is for that reason, both for all of the parties, it's incumbent upon them not to introduce discrimination into the process of jury selection, and that's incumbent for the parties, but also for the impression of having a fair jury system where members of the public who don't have access to the jury questionnaires, they don't see it as though every one of a particular background or the only one of a particular background are being struck. That was, it doesn't quite matter because part of that public impression is fairness in the jury system, and it would have conveyed unfairness in the jury system if she were permitted to be struck for an apparent membership in a particular creed, in this case a creed that the victim also shared.
But a creed that was actually going to be, in fairly despicable terms, criticized as part of the evidence in the case.
Certainly, Your Honor. However, there are cases that this court has addressed. I believe Prunty was a situation where similarly there was going to be statements that related to racial animus, and the defendant attempted to strike the only black juror who was going to be seated, and the judge properly declined to allow that challenge.
Did the judge question the juror?
The judge in that case did question the juror, and it was asked.
Does that make a difference here?
Your Honor, the defendant did not ask for the opportunity to question the juror. This was after all of the challenges for cause had come up. It would have, had the defendant requested there be questioning of this juror, that would have been something that the judge could have done. However, the judge was entirely within his discretion in declining to allow this challenge. That further inquiry was not made. It wasn't an inquiry that had a basis, because this juror's questionnaire, as the record reflects, there was nothing to suggest that she would be anything but impartial.
And there was never a request to challenge, I mean, the lawyer did not ask to say she should be, I'm challenging her for cause.
No, he did not say that.
Can I, let's turn our attention, if you would, to this other condition, this third condition, that she will be required to make written disclosure to all prospective tenants that she is an assaultive person, essentially that I have violated tenant rights in the past. She's required now to make these written disclosures to anyone who is a prospective tenant, right?
Your Honor, she's required to provide a written disclosure to her tenants and prospective tenants that she has assaulted a tenant and that she's been the subject of harassment orders in the past.
And that she's been convicted.
And convicted.
Convicted, I apologize, yes, of assaulting a tenant.
So could the judge have said, I want you to actually post a huge poster in the front of all your buildings announcing to anyone who might go by or might be interested in coming in, this very information. This is a notice that I, as the landlord, have been convicted of assaultive conduct and am a really obnoxious person. Now, do you think that would be okay?
No, Your Honor, that wouldn't be okay. Unlike in this.
The difference.
The difference is that in this, there's a limited class of people that the information is being conveyed to for a limited purpose, which is public protection of those particular tenants. Again, the record here shows that this defendant had a history of trouble with her tenants, or really that her tenants had a history of trouble with her.
Well,
And the difference in that broad posting is it's not something that's directed or provided to people whom she may be putting at risk. And there's also a major shame element to that that is not present here. This is a limited disclosure to a limited class of people for a limited purpose.
Is there, you suggest, but I'm not sure you're correct, that there isn't that there's no Corey problem because this would, just on the conviction piece, because a member of the public could go to the police station, but that's always the point about these things. There's a huge difference between going to the police station and looking it up and being told the information. I mean, why isn't that a Corey problem?
Your Honor, the defendant is not required to provide a blanket copy of her Corey.
Well, she's required to say that she's been convicted.
She's required to tell these particular individuals that it would potentially be engaged with a landlord-tenant relationship, that she has this history. And as the judge stated on the record,
But history's different than conviction. That's what I'm...
that she has been convicted of assaulting a tenant. It is directly, the Judge G stated below that part of his concern with that is that her tenants provided the opportunity to know this for their own safety, and then they can make a choice about whether they wish to engage her as a landlord. That's something that they can.
How about
with
if we
more
look at
information.
that as an economic condition, because it's hard to think that anybody knowing that would actually rent one of her apartments. So how is that fair to subject her to this kind of continuing economic sanction for probation, as a probationary condition?
Your Honor, Power makes clear that even when there are financial considerations that are affected, and even when fundamental rights are affected, that provided that the terms are reasonably related to the goals of probation. In this particular case,
Okay,
as
well,
to the
that's the
disclosure.
question I'm trying to ask, and I probably didn't do it very clearly. How is this kind of continuing economic sanction reasonably related to this rehabilitative goal of probation or whatever it is? I mean, if anything, it would tend to make her destitute, which might make it difficult for her to comply with other aspects of the probation.
The fact that it may reduce the market rate of her apartment is something that doesn't violate the standards set out in Power. This defendant, I would note, Your Honor, has never shown that she has had difficulty renting. As the court noted...
Yeah, because they didn't know about her history.
Well, as the court noted in Des Solettes, what the actual burden is needs to be weighed with the market forces if there does turn out to be a burden. I would note for this court that in terms of both her religious beliefs and in terms of this disclosure requirement, she has never asserted which of her rights are being burdened. She has never stated, this part of my Christian faith is offended by participating in an academic course on Islam, and she has never stated which she would have the opportunity to the judge below to present, that telling this information prevents her from earning an income. That's something that the judge could be given an opportunity to consider.
Well, I mean, on this one, it seems it kind of hits you in the face. I mean, why does she need to say it? It's obvious right?
Well, it may have an effect on what level of rent she can collect, but there's just the fact that market forces... Your Honor, I would suggest, as the Des Solettes court noted, what is one of the things that the court should consider, if it comes up, is the market forces and whether a person is precluded from finding, in the Des Solettes case, a rental property. I would suggest that in the greater Boston housing market today, where it is a very tight market, people rent all sorts of apartments, and it may mean that she can convey a lesser rent or collect a lesser rent, but it's not equivalent to precluding her from earning an income.
right, thank you.
Thank you.